Hey y'all, it's me. It's your girl, the real deal. Oh, you already know. Like, share, and subscribe. What's the real deal? How y'all doing out there? Now you know we back into these October months now. October months gonna be tough for these cases, right? Okay, we got to get it and we got to run with it. We got to do what we got to do. Now the title of this content is Bryan Kohberger murder trial. Motion to keep cameras out the courtroom. That's what they trying to motion. But they trying to desire to keep motions out of the courtroom. Though the media has filed a motion to intervene, requesting that cameras be allowed to be present. And cameras should. This case ain't no different than the other cases. But when the judge, uh, when the judge questioned the right of the media to intervene in the issue surrounding the allowance of cameras in the courtroom, the attorney representing the media immediately began arguing about the public access and an increasing need for people to see for themselves what is going on, which is true. Now we don't have to see. They can put it in the courtroom, but we don't have to see the person. You know what I mean? So the judge continued to express his thought that the media cannot be considered as interveners at this point, but will take the argument under consideration when deciding whether or not to allow cameras in the courtroom for future proceeding. Okay, the defense expressed their concern for the spectacular that could be created by allowing cameras inside, more based on the manipulation of the video and image public consumption. Well, if y'all gonna do that, y'all got to do that for all cases, okay? So the defense team suggests that if one camera is allowed, it would be positioned somewhere else so that it is not directly behind the defense team. See, what they trying to say is they keeping the camera over there on they keep they keeping the camera on Bryan, y'all. That's what they saying. They can do that and they can take it off and put it toward the judge, but it's about Bryan Kohberger. So the state, although acknowledging the media plays an important role in the judicial process, which they are right, is concerned about protecting vulnerable witnesses and graphic evidence, arguing the best way to achieve it is to keep cameras out or at least limit the times cameras can be used. Now, that's what I just said. The judge expressed that he believed the media has already pushed the envelope and cited the O.J. Simpson case as an example of the cameras in the courtroom creating a circus. His concern, he says, are in how commentators talk about videos and how it is used. The attorney for the media continues to argue that without cameras, people are left to speculate without having the video to convey that actually happening. And perhaps a better solution would be to keep the cameras in the courtroom, but disallow cameras outside the courtroom. Wow. So the defense went on to point out that their goals is not to keep the media out, just the cameras. They was talking about the camera. They want the media there, but they don't want the cameras in there, y'all. That's what they saying. So the judge would take the argument into considerations, including the suggestion of possibly moving the location of the cameras within the courtroom. He will issue a written ruling as a later date. So we'll find out if they gonna have cameras or not, y'all. All right, let's take a look at the video. You know, I always have videos to my content. Uh, let's check it out.
Today, the man accused of murdering 4 University of Idaho students last November is expected to be back in court.
KREM 2's Nicole Hernandez joining us now live from the newsroom with more on what we can expect from today's hearing. Good morning, Nicole. You've been covering this for almost a year now. So what's expected to happen in court today?
So, Tim Channing, today's hearing is for a motion the defense filed to get rid of cameras from the courtroom. They filed this motion last month. Court documents say camera operators in the courtroom did not listen to the judge asking them to focus on more than just the suspect, Bryan Kohberger. The defense says people are overanalyzing Kohberger's body language in social media posts. His attorneys say that under the 6th Amendment, he has a right to a fair trial. They say the more people see him in hearings, the more it could unfairly prejudice the trial. Now, last week, the prosecutor in this case filed a response to this motion, largely agreeing with it. The prosecution says the court should ban cameras because it could make vulnerable witnesses, some who have already faced harassment, afraid to testify. Yesterday, KREM 2 heard from the families of Kaylee Consalvis and Xana Kernodle, 2 of the victims. They're asking the judge to allow cameras in the courtroom. The statement says in part, quote, "It is vitally important that the trial be viewed publicly. It is important to the victim's family, relatives, community members, and the public that this veil of secrecy be lifted at trial. This not only ensures accountability for all the parties involved, but also helps the public maintain its faith in the justice system," end quote.
I agree. I agree with everything. I like Gazelle's father. I like him. I really like that man. He stands up for his daughter. John Cavis, yeah. I like him. I really do like that father. Man, let's see what they fussing about right here. Right here, what they talking about right here. I got to keep up to
With
that.
NetJet, our standard is not just to meet.
Keep up with this case, y'all. But I be so busy with other cases. And this is the courtroom they talking about the cameras, y'all. Bryan don't want nobody looking at him.
Thank you very much. Please be seated. All right. Well, good afternoon. Let's get on the record, please. Thank you. We are now on the record. Stop. Only on your computer. I'm moving around.
They got the camera on the whole courtroom. That's good. Oh, they put it on Bryan. Oh, Bryan, you the star here.
Okay, good to go. Let's try this again. Can you hear me? Can you hear me, Ms. Beatty, Mr. Nye?
Yes.
Yes. Ms. Messa?
Yes.
Okay, excellent. Okay, we are now on the record. This is State of Idaho versus Bryan Kohberger, CR 2922-2805. Mr. Kohberger is in court with counsel, Mr. Logsdon and Ms. Taylor. Ms. Massett is participating or observing from Zoom or through Zoom. The state is represented by Mr. Thompson and Mr. Rudley, who are in the courtroom, and Mr. Nye and Ms. Beatty are observing through Zoom. We also have Ms. Olson and Mr. Carone representing the Media Coalition, and Ms. Towler is the court reporter. So welcome back, everybody. And I think what we need to do is first address the motion to intervene. So, Ms. Olson, is that for you?
It is, Your Honor.
Thank you.
Your Honor, as with the motion that proposed interveners filed before the court, we seek to intervene for the limited purpose of opposing the defendant's motion to remove cameras from the courtroom. It's our position that the proposed interveners are the ones who are most affected by that particular motion. And in light of the court having asked us, essentially the same group of interveners, to weigh in on this issue before, we would seek to intervene again just for that limited purpose of opposing removing cameras from the courtroom. I think it's within the court's discretion to do so.
All right, thank you. So I see this. Oh, don't go away. No, I want to talk to you about this because I think that, well, I'm not sure, okay, that this is the same intervention as we had at the first round. I think this is a different situation. And I think some of your clients kind of jumped the gun a little bit, thinking that they are interventions or interveners. And I mean, you know, this was filed on August 30, 2023, so we really haven't had a chance to talk about this. And I haven't addressed it in court, as you know. So, and we already started with the merits, okay, before I have approved the intervention. So my issue first is really on the standing, because the first round had something to do with Constitution, state Constitution, UN, and I'm not sure that applies in this situation under Rule 45, and I think that the Supreme Court, the Idaho Supreme Court, sort of addressed that a little bit in the former motion for mandamus. So, you want to address that, the standing issue first?
Sure, Your Honor. With respect to the Supreme Court's decision, when we filed a petition in front of it back in January, I think they said that the media has the right and should be able to intervene when there are issues related to First Amendment issues and access issues. And Your Honor, I would submit that, and we understand that ICAR 45 is absolutely the governing piece of law on this. But when we talk about press access to the proceedings, cameras in the courtroom, I would submit, Your Honor, are part of that press access to the proceedings because it's the cameras in the courtroom, it's the ability to have full coverage, it's the ability to have still photographers that provide access to a much greater number of people than even having just the reporters who are going to write things down and post stories after the fact. It allows sort of that broader access that allows people to see sort of firsthand what is happening, and we think that's an important First Amendment right, Your Honor.
Attention business owners. If you're a business owner, you can get free access to this book, 67 ways.
To have cameras in the
Absolutely First Amendment right.
So the press and the public have full access to this courtroom.
I agree, Your Honor. Having cameras in the courtroom, having still photographers, having live coverage allows that public access to be much greater than it is through just having people having to travel to Moscow, having to come into this particular courtroom, Your Honor.
That has no implication for the United States Constitution or the Idaho Constitution. I just want to clear this issue up in terms of what the standing is.
Your Honor, I respectfully disagree because I think that the First Amendment and the Idaho Constitution both contemplate this right broad access piece of it. And I think there's an argument to be made that having cameras in the courtroom takes a step from that right of public access and makes it more open to additional people. So I think there is a First Amendment interest there. It's certainly not as strong as, for example, if the proceedings, there was some sort of order to close the proceedings or no journalist could come into the courtroom. I think that would be a far more significant problem, Your Honor. But I think in terms of First Amendment interest, the broader, and maybe because there's some access already, the First Amendment interests are smaller, but I think there is a First Amendment interest in having broad access to the court proceedings. I think it's also in the interest of the court, Your Honor, to make that access as broad as possible, because we're unfortunately in a day and age where for some people, if you can't see it, you don't believe it, or if you can't see it, it didn't happen. And there's an increasing need for people to see for themselves precisely what's going on inside the courtrooms of this country.
Are there cases that support that?
That support cameras in the courtroom?
No. And that is based in constitutional law.
Well, Your Honor, I would say that the line of cases that we both cited, Estes in Chandler versus Florida, says that there's no prohibition on having cameras not in the courtroom. There is not a case that says flat out, under the First Amendment, there is a right to have cameras in the courtroom.
Okay. Well, I understand that. Let me, because I was looking back at this decision that the Idaho Supreme Court made, and it does say that petitioners, meaning you in that case, or your clients, I should say, are correct that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case. Likewise, the federal rules of criminal procedure do not provide for a motion to intervene in a criminal case brought by the United States. Of course, you know that well. It says, however, both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties in the defense of public access and free speech, including in Idaho. So I think, we're on the same page on that, and I understand that. This idea of intervention specifically versus as an interested party, because I know in the Daybell case, the media was characterized as interested parties. I'm just not sure that we get all the way to intervention, because historically anyway, my understanding of the rules is intervention means you are really a party in the case. And that gives you significantly more access. I'm thinking about this more as an amicus brief or presentation, because I'm willing to hear it. I'm willing to read the briefs. I think that's important, but I'm not necessarily comfortable going to call it all, or the media coalition to be interventions. So do you see a difference there?
Your Honor, I understand the difference, the distinction that the court is making. That's why our motion to intervene has always been for a limited purpose. And full candor, this was a difficult one to sort of try to solve procedurally. It's been my experience in Idaho state courts that rules and cases are read very literally, and we couldn't find a rule, so that's why we went to the Supreme Court to begin with, because there wasn't a rule that allowed us to do that. And I think for purposes of the proposed interveners, the media coalition in this case, that being allowed to present its argument to this court, whether it's as interveners for a very limited purpose, and that's without a rule, that's typically, I think, how you would get into a case. I was trying to liken this to like, motion to quash a third-party subpoena, but there's a rule that allows you to come in and challenge that. So when there was no rule, we were trying to identify, well, what is the procedural mechanism? And intervention is typically, certainly there's a civil analog, and there's a way to, that's just the analog that we requested from the court before. We think it's consistent with what the Supreme Court said in the case that it decided in April. But if the court does not want to give us intervention status, I remember we had that discussion a little bit last time, and we asked you to sign the order, so in part that would be precedent for us to do this, and you did.
Yeah.
But
Everybody
if-
agreed, so I
Yeah.
signed it. But now I've thought more deeply about it.
Yeah, and I think, Your Honor, if the court would rather the media coalition appear as interested parties, I mean, that would also serve the media coalition, and they'd be happy to present argument just as interested parties, so that there is some entity speaking for continued access in the courtroom.
Okay, and I could even label you as media coalition.
Are you a professional or a
That would be fine with us, I think, Your Honor.
Okay, great. And there is some language, and I don't need to read it now, on page 14 and page 15, that kind of caution going too far with intervention, or what we call it. I'm trying to clarify this a little bit. I think the Supreme Court is trying to clarify it a bit in criminal cases. My reading of this is they really don't want the media to just be coming into the middle of criminal cases to, I guess, exercise their concerns.
And I don't think the media wants to either, Your Honor. I think both with the initial motion to intervene and the issue that was raised last time about the non-dissemination order, and both this issue with respect to cameras in the courtroom, those are both about sort of fundamental access to the sources of information that this trial, this proceeding are really all about. And so that's, I think, the media doesn't want to have to, they don't have to pay me, Mr. Crone, every time they want to make an argument in court, and we don't think that would be appropriate either. It's just those issues that really fundamentally affect what sources of information they can access in the process of reporting on this story, Your Honor.
Great. Thank you, Ms. Olson.
Thank you, Your Honor.
I'll give the first. Mr. Dudley?
Yeah. Well, Your Honor, the state has no objection to either classification of the media for the limited purpose of helping the court decide this issue.
Okay. Thank you, Mr. Dudley. Okay, Mr. Logston?
We're not going to object, obviously, to hearing from the media, and I certainly understand the court's concern, and it's interesting, but and so long as I guess they're not filing things willy-nilly and making discovery requests, we're not terribly concerned about how they're doing that.
Great, thank you. Maybe I'm just being a little nerdy about, the rules and, even the history in Idaho, and also relying on some of the language in the petition for writ of mandamus that the Supreme Court issued on, I guess it was April 24, 2023. So I really think it's more appropriate, and I looked into this to some level, and to sort of an amicus brief, but not considered as a party, as an intervention, particular issues of interest that are important. No question about that. So that's how I'm going to view this, to be for intervention. I have a hard with that, but however, I will certainly consider the arguments, consider the briefs, and I will consider that while balancing the concerns of both the state and the defendant too. So let's move then to the arguments on cameras in the courtroom, and we'll start with Mr. Kohberger's team, and I believe that's also going to be you, Mr. Logston.
Sure, I don't intend to take a lot of time. We've briefed this. Moreover, we somewhat argued it a few months back. I think our position is that the court, I think, understands our concerns about turning this into a spectacle, the way that that may prejudice the public against our client, the way in which that dehumanizes people, constantly shown, and turn this into more of a TV show drama than a court proceeding, which is what it is. And I think everyone understands that. Our concern is that since that time, it doesn't seem like much has changed. The media's argument, as far as I can understand it, is that the cameramen that are here are doing their jobs well. There are editors for various organizations, or people on social media that take those images and then do things with them that we may not like. And that if the court removes the cameras, presumably those people will just use older images, and we want to perfect things all very far. Our position is that removal of the cameras does two things. One, it stops new images, and I don't think we can underestimate the power of novelty when it comes to what the public is interested in. Use of old pictures becomes ho hum. There's a reason why we live in a world of memes where people are constantly trading around pictures. They quickly get old. There's a new one. It seems like every day there's hundreds of brand new images. So the concept of removing this sort of almost sideshow from what's being put out there, we think would be an important way to kind of take away the sensationalization of this case and just kind of reduce it to hopefully the words on the page. And if they're using old photos, etc., you can't stop them. We just don't see that as being as big an issue as a constant stream of new images that are being manipulated, etc., to make.
I don't know what he talking about.
The smooth, seamless, and secure flow of documentation is critical.
Bryan, I want cameras.
Our secondary point is that if you look at it from the side, you can't quite see what I'm doing anymore, but it's a distraction for us because we feel like essentially there's a camera right over our shoulder, and we certainly understand they're not zooming in on what we're doing, but I think we've already seen that once they make these images and they pass them around, I mean, they're all make cameras, and somebody else could presumably do that, and so that causes us quite a bit of concern as well. So if the court decides that removal of the camera isn't necessary, we do have, I think, a bigger concern of just making sure that they're set someplace where we don't have images that are really just what we're working on during the case. And I don't really have much else to the court, unless the court has questions for me.
Well, I have one comment or question, because in one of your briefs, I know I've had two sequences of briefs because we had this earlier, but this was a newer one where you were saying, well, this is a quote, were it only the kind of cameras used to show the workings on the House floor on C-SPAN.
I may be showing my age. They might have better cameras now, but when I was
I'm sure
younger, it was just this camera like way over there.
Yeah, well, that's the point. I mean, I made me think about that, is just plant a camera up there. If everybody can just see what's happening from the back of the courtroom, maybe that can satisfy everybody just partly.
That was kind of my idea, Judge. That was my suggestion. And I feel like somebody's going to throw a tomato at me, but that I thought might be a way to kind of give a little and just kind of protect what we're trying to protect.
I've never seen anything very sensational on C-SPAN.
And that's literally what I was thinking.
Yeah. That's
Although you and Gingrich got pretty close.
Yeah, there you go. Okay, well, thank you.
Thank you.
Okay, are we going to Mr. Redley now? Yeah, Ms. Olson gets at the end of that, and then I'll go back to the parties. Go ahead.
Thank you, Your Honor. As we previously discussed, the decision of whether to allow cameras in the courtroom is discretionary for the court. The state outlined our concerns with allowing cameras in our responsive brief and in our June's briefing. Primarily, those concerns are preserving the right to a fair and impartial trial for all the parties, protecting sensitive witnesses who will testify at hearings and trial in this case, and safeguarding evidence, which is the graphic nature. We agree that the media plays an important role in the court process, and we appreciate in their briefing the measures that they identify to address some of our concerns for protecting vulnerable witnesses or evidence which is of a graphic nature that they've done in previous cases. However, our contention is that the safest way and best way to address all of these concerns is to prohibit cameras in the courtroom, or in the alternative, prohibit cameras when sensitive or vulnerable witnesses are testifying or there's evidence being viewed that's of a graphic nature. And I'll stand for questions.
Okay, thank you. Okay, Ms. Olson.
Thank you, Your Honor. And I think, legally, we're where we were 3 months ago with respect to what the rule the court has to consider in terms of whether to continue to allow cameras in the courtroom, and that's Idaho Court Administrative Rule 45. And I think, Your Honor, when you read through that rule, it really addresses the concerns that the parties have raised to this court about what the court's discretion is, about what it can, how it can direct cameras, where they're to be in the courtroom, all of those things, that it can restrict camera coverage when there is a particularly sensitive witness. And I think, Your Honor, what you saw in the declarations that we submitted, the declaration of Rebecca Boone and the declaration of Grace Long, is that these are journalists who are experienced in covering court cases, and in covering court cases where there are cameras, both video cameras and still cameras, and following the court's admonitions about what can be covered and what can't be covered. And I think, particularly, Your Honor, with respect to Ms. Boone's declaration, and Ms. Boone, who's a graduate of the University of Idaho's journalism program, who continues to be an advisor to that program, and who certainly would have not only the best interests of her employer at heart, but she understands this community. I mean, her experience has been that when you have these pool cameras, both still and video, and when you allow camera coverage to the extent that you can, it better serves the public, and it helps ameliorate the kind of media scrum is probably not the term that my clients would want to use, but the sort of that big gaggle of journalists who accumulate outside of the courtroom when there is no opportunity to be inside the courtroom, when you don't get the opportunity to have that full procedure. So I think the court can use Idaho Court Administrative Rule 45 and craft a solution that continues to allow the journalists who are working hard to cover this case to be able to do so in a way that both allows them to provide really a first-hand account of what's going on. And again, Your Honor, I don't think we can underestimate the importance of that first-hand video account as well, because we're just in this day and age where people are used to seeing things.
Recordings just got better.
Ooh, shit.
Everywhere, to be able to really have great confidence in the proceedings, I think it is important for the court to allow some sort of in-courtroom camera coverage of the proceedings. People are going to need to be able to see firsthand for themselves how the evidence is presented, how they want to see the rulings in court. They can learn a lot from that in a way that they can't learn from people who then are in the courtroom and they go set up outside and they talk about what happened. And so I think that's a good reason to continue the policy that the court has had And then I think, Your Honor, with all due respect to Mr. Lawson, I just don't think there are the violations of the things that the court said at the outset of the June 27th hearing. I was not here. I read about it in the attachment that Mr. Lawson made to his initial, or the reference Mr. Lawson made to his initial pleading in this round. And my reading of that, Your Honor, is actually in a Fox News story, is that the court said, and of course the court said it, so I'm sure the court's memory of it is that the court should, of course I'm having a hard time.
Back up. That's what I said. That's one of the things I said.
Yeah, okay.
It was just focusing too much in particular areas. And so I was just cautioning the media to step back, and they have pushed the envelope.
Yeah.
I'll tell you that.
Okay. Well, Your Honor, I think that what the media heard on that occasion, as reported by Fox News, was that the cameras needed to show a wide shot of the courtroom and not focus strictly on Mr. Kohberger. And I think that phrase for focus strictly on Mr. Kohberger has to been interpreted. You can still take pictures of Mr. Kohberger, but he's not the only one you should be taking pictures of. And there's certainly a limitation in print media or the online stories. I mean, you don't always have video. So what I've seen, and I think that this examples we provided to the court, where there were pictures of lots of different participants in the courtroom, and they're trying to show everybody. And if the direction from the court is instead, look, there can be no single pictures of Mr. Kohberger, the challenge is, and I think even Rule 45 says this, there are some limits on how much the court can tell the editors and everything, because they're not here in the courtroom. And some of those people may still choose to crop out just a little bit of that picture. And Your Honor, I don't think that runs afoul of what the court has in mind. I think that what you've seen is an attempt by the journalists who are here in court to show a wider shot. I mean, as we were in our brief, from that courtroom angle there, I mean, it's, I think I said it's not a football field. It's hard to get sort of the full perspective when the camera is sitting right there. If there's a way to station the camera at the very back of the courtroom, maybe, but those are also the things, like you saw this in Ms. Wong's declaration, the court TV people have a lot of experience working with courts and trying to find the best way to both serve the purpose of having cameras in the courtroom and being able to present to the public the proceedings as they occur, and also not be obtrusive, not cause noise, not run afoul of the court's admonition to focus in on any particular individual. So they are more than willing to work with the court to do that. They just have to continue to be in the courtroom, because I think when we look at the full media coverage, they haven't run afoul of that admonition.
I'm gonna skip a little bit, yeah.
I covered ones. I think the point of that one was too, like, look, you can have camera coverage of these cases, and the person, it's still possible for them to get acquittal. It's not prejudicial in terms of guilt or innocence to have cameras in the courtroom. But I think everybody learned a lot from that trial. It certainly didn't reflect well on poor Judge Ito. It didn't really reflect very well on the prosecutors. There are things that may have been playing to the camera because of that. But I think we all learned a lot from that, Your Honor. And hopefully, then changes can be made about where the cameras can be positioned. And there's part of it's the responsibility of the participants in the courtroom, not to adjust their behavior for the cameras. I don't see, Bill Thompson, the late Cobb County prosecutor, years and years and years, adjusting his approach, or Mr. Nye, or the others who are working on this, because there are cameras in the courtroom. I know Ms. Massoff, I don't know these lawyers as well. I know Ms. Massoff is not going to adjust her performance in the courtroom. She's going to do everything she can for that client, and I trust these lawyers will too, regardless of whether there are cameras in the courtroom. And I think, Your Honor, the public and this community will be best served by having those cameras in the courtroom and making sure that the guidelines that the court wants to put in place are there, and that there's this firm understanding by members of the media that they will follow that. And I just think it's just not true that these are that the people who we represent and the people who are in this courtroom today are here to make a spectacle of this proceeding. Thank you, Your Honor.
Thank you, Ms. Olson.
All right,
So
girl.
I hope I sent out a message to the media and everybody else that please have patience, be respectful, and be decent.
You may have tried dropshipping in
That's
the
right,
past.
Judge. Tell them, honey. Just said that. Well, y'all, there you heard it. What do y'all think? What are y'all thoughts on the cameras been in the courtroom during a murder trial? What are y'all thoughts on this Kohberger? Do y'all have a problem with the media being in? They don't have no problem with the media being in that. They have a problem with the camera. So put in the reaction box over here what you think. Okay, y'all have a good night, day, evening, wherever you're from.